Mommy, I don't want this memory anymore. Mommy, I'm scared. These are the words that my 6-year-old daughter told me on February 6th, 2026.
And
Why are you kissing a 6-year-old with your tongue? That's why are you penetrating a 6-year-old with your penis? I mean, you pled guilty to it.
Yes, ma'am.
So I'm trying to figure out what were your thought process when you were penetrating a 6-year-old with your penis in the vagina and anus?
I wouldn't have a probable cause that has an allegation that there was 96 text messages, 47 emails, 9 voicemails left stating that you don't care what the protective order says and that you're going to do what you want to do.
All right, court is calling. And I'm going to need everyone to be quiet in the box. Court is calling 2019 CR 6589, State of Texas versus Jonathan Rodriguez. Can I have parties announced for the record for the state? For the defense? All right, are you Mr. Rodriguez?
No.
All right, have both parties had a chance to review the PSI report in state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Any objections to the PSI report, state?
No, Your Honor.
Defense?
No, Your Honor.
Are there going to be any witnesses or just argument?
Just argument.
All right. Mr. Rodriguez, you entered a plea to indecency with a child. According to the plea bargaining agreement, punishment is to be assessed at a cap of 15, and there's to be no contact with the complainant and Chapter 62 registration. The state is opposed to your application, state?
Yes, Your Honor. And I'm to be proceed with argument, correct?
Yes.
I didn't want to assume anything. Sorry. So based on the offense stated, if you look at the child's date of birth compared to the defendant's date of birth, the child was 6 years old at the time of the offense, and the defendant was 28 years old at the time of the offense. This case is even more aggravated in the fact that this child, when she went and had her SANE exam, the fact that she had a SANE exam is terrible in itself. But as a result of that, she tested positive for chlamydia in both her anus and in her vagina. What's contained in the STIPs, and I believe the court can consider, is that this child said that he penetrated her anus and her vagina. And so it's clear what other way other than some sexual act by somebody does a child get this? And so these cases are already egregious in the nature that we have a child victim whose innocence has been stolen from them. But what's even more aggravating is the age difference of this child was 6 years old at the time of the offense. And what's even more aggravating is the fact that this defendant, presumably, all the evidence suggests that he is the one who caused her to have an STI at the age of 6, maybe 7 at the time of her outcry. And so we are asking, and I believe justice demands that you deny his application for deferred adjudication, and that we ask that you sentence him to the full 15 years because of the aggravating nature of this offense.
All right, defense?
Your Honor, obviously these are aggravated facts, but these cases almost always involve aggravated facts. And I think, Judge, what is going to determine how this case goes is whether or not the court believes that my client is worthy of redemption. And I would say that he is. I am asking that you put him on deferred adjudication. Notwithstanding the horrible mistake that he made, he has no criminal history. He's never been convicted of a felony. He's never done time in prison. He's never done time in county jail. This is his first offense, and it is a horrendous offense. But the fact remains he has no criminal history whatsoever. Further, Your Honor, if there is deferred adjudication, as the court knows, the court would not be limited to the sentencing range that it's limited today in the event that Mr. Rodriguez were to violate his deferred adjudication. Mr. Rodriguez at that point would be facing the maximum, which I think gives him incentive to behave himself while on deferred adjudication. Also on deferred adjudication, the court can order the treatment that he needs in order to rehabilitate himself. And the court could also order conditions to protect the complainant from the defendant. I'm asking, Your Honor, that you put him on deferred adjudication. This is a horrendous thing. There's not really anything I can say about that. But the fact is, I think he's worthy of saving. He has no criminal history. And I do think that I do think that he could right the ship, so to speak, Your Honor.
All right, anything you wish to say?
Um,
Can you raise your right hand for me?
yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand. So before you decide to testify, if you decide to testify, the state, of course, is allowed to cross-examine you. Do you still wish to testify?
If I ask you questions, he can ask you questions too. You have to answer. Okay.
All right, what would you like to say?
No, about the probation, if you do give it to me, you know what I mean?
All right, I thought you wanted to say something about the actual
Oh,
allegations.
no. I was gonna say about the probation. Now, if you do give it to me, I promise, Your Honor, that I'll prove to you. And also I'll prove to my brother that's back there and my mom also. And
Why are you kissing a 6-year-old with your tongue? That's what I'd like to know.
why am I kissing a
6-year-old with your tongue. I read all of the PSI reports.
I don't remember doing that, Your Honor.
Why are you penetrating a 6-year-old with your penis?
I
mean, you pled guilty to it.
yes, ma'am.
So I'm trying to figure out what were your thought process when you were penetrating a 6-year-old with your penis in the vagina and anus?
It was, yeah, I know I messed up and, you know.
Well, no, my question is why? What were you thinking while you were doing it? That's what I'm trying to figure out.
I just can't remember, Your Honor.
Okay.
I'm sorry.
I mean, I'm just asking questions.
All right.
All right, defense? Any questions?
No, Your Honor. As the court sees, there's what can he say for this? It's horrendous. I just asked the court to show mercy.
All right, any questions?
I think you said enough, Judge.
All right, this is what the court is going to do. The court is going to find you guilty, sentence you to 15 years in the prison, give you credit for any time served. There's Chapter 62 registration and no contact with the complainant. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it and did you sign it?
That's fine.
Because it's the plea bargaining agreement, because I followed your plea bargaining agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. I understand that sometimes people regret what they've done, but we can't turn back the hands of time. So you need to internalize what you've done and hopefully this won't happen again with you. You understand? All right, is there any impact or no?
No, Judge.
All right, thank you.
Good morning. Are you Justice Joanna Lewis? And this is cause number 24, DCCR 0766. Ms. Lewis was granted probation for aggravated assault with a deadly weapon back in September of 2024. This is a motion to revoke. She pled true to counts 1, 2, 3, and 4. I've received an updated pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor. The state has to.
And this was unagreed, correct?
Correct. Yes, Your Honor.
All right, Mr. Parker, you may proceed.
Your Honor, just first like to point out she has no new cases. Part of her issue, I mean, she's not reported. She's claimed some mental issues, which although the probation department didn't have knowledge of, I think they've confirmed that by talking to the infirmary, the jail. And I believe she did have issues. She was in a wreck and I can tell you she's acknowledged to me that she's told me the right things, which was promising, that she didn't go to probation because she was in a wreck and she was uncomfortable and it's hard to her. She also acknowledges, I should have gone. I should have had better contact with my probation officer and done what I'm supposed to do. She's very convincing to me that if she's given the opportunity, she's taking the medications that she needs to take and that she will be able to complete her probation. I'm asking the court to put her on the high medium caseload and see if she does what she says she can do. If she's on her medication and, we can see if she actually will report. I mean, it won't take long to see if she reports and she starts doing a community service. They're administrative violations pretty much, and I'm asking the court to give her another chance. And do you want to address the court? Hold on. And she'd like to address the court, Judge.
Go ahead.
I would like for another chance, and I promise that I'll make sure that I do all my things that I'm supposed to do for my probation.
Explain to her what you told me about why you didn't do what you were supposed to do the first time.
I got in a car accident, but like I say, I'm not using it as an excuse. But I was out on transportation and stuff like that, and I couldn't really make it to where I was supposed to make it, and I've been taking my medicine. I've been doing everything that I'm supposed to, and I promise that I'll continue doing everything that I'm supposed to do to complete my probation.
And you told me what should you have done when you weren't going? You should have done what?
Should have reported.
And you should have communicated with them.
I should have communicated, especially with my probation officer.
Mr. Coleman?
I don't have much to offer, Judge. Same things and making representations. They're easy to do and easy to say, but it's the deeds, the actions of the defendant that matter. And Judge, she's essentially done nothing on probation. If it's a mental health issue, she's got to take the first step, Judge. She has failed to enroll in Spindletop to get those mental health, mental health issues, if any, addressed. You can't do this probation for her, Judge. And the definition of insanity is doing the same thing over and over and expecting a different result. Putting her back on probation, given the fact that she's just utterly failed, would be, in my opinion, doing insanity, doing the same thing, expecting a different result. She's just not going to. Her past behavior has indicated she's just not going to be successful at probation.
Well, to be honest, I don't think that's fair representation, because obviously the probation department didn't know she had a mental health issue. They acknowledged that. And when they do know that, they take steps to help these people that have problems. And she did take steps to get on medication, and she has improved by being on medication. I think with the assistance and the knowledge that the probation department has, that she has a mental health issue, and she actually is taking medication for these problems, it may help her. She may have a better chance.
So I'm looking back at the original pre-sentence report from 2024.
Mm-hmm.
And so it was noted in that pre-sentence report in 2024 that she had an appointment with Spindletop for a specific day that she failed to show for during the pre-sentence report, that time period. So it's not a surprise to anyone that there was some issues back then that weren't followed through with to go to Spindletop. That was ordered at it was in the order back then for her to be assessed for services at Spindletop, which never happened. So here's the thing. Here's where I am. I don't disagree that, Miss Lewis has really no criminal history. This is the only case. There's clearly some mental health issues as well as drug issues. But I'm not going to just say, okay, go out and do Spindletop, because we've already said that a couple of times. So what I am going to do, and this is your opportunity to take advantage of this, Ms. Lewis, is I'm going to find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. I'm going to find those counts true. I'm going to find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to continue you on probation, but I'm going to order that you enter and successfully complete the special needs safety program. That will address all of these problems. If you say you want and need help, won't matter if you have transportation, you'll be in custody to get the help that you need. Either you take advantage of that or you don't.
Yeah.
So you're going to get all the tools for both mental health issues, drug use issues, self-medicating, all of that. And when you get out of SafeP, you'll be on the high medium caseload in order to do whatever it is to follow up with Spindletop, follow up with drug treatment. And at that point, if you don't do it, there's no arguments that your attorney can make that would convince me that you should get another chance. This is your chance. Do you understand?
Yes, ma'am.
So this was not an agreement. You do have some rights to appeal. I'm handing you that written certification. I hope you take advantage of this and get everything you need, because you'll be given that opportunity, okay?
Yes, ma'am.
All right, good luck to you. And Megan, I'll get you next. All right, sir, you Gabriel Cruz?
Yes, ma'am.
And we've got cause numbers 26 DCCR 0373. Mr. Cruz is charged with stalking. Cause number 26 DCCR 0374, charged with violating a protective order. And then cause number 26 DCCR 1060, charged with violating a protective order. And the state has filed a motion asking that I increase the defendant's bond. Hold on, I need to see what the bonds are in each case.
I believe they're $100,000
In all three cases?
Well, individual, $100,000 in each individual.
300,000 total.
That's
Yes.
what I need to know.
Yeah.
All right. And has not made bond in any of those. Is that
He-
correct? Or he
He
has?
made bond in the first two, and then he picked up the last new case, and he's in jail on that case, on that. He has not bonded out on that charge.
And the last offense, it looks like has that same
The-
offense date. It was just indicted on, at least on my docket. Let me look at that.
Oh, it's
because-
a different offense state. It's my understanding.
Let me look. Oh, okay. Hold a second. Offense date. It's not, okay. It's not. So the offense date in that last one is March 1st of 2026.
That's right.
So 2 weeks or so after the first alleged offense of violating a protective order. Mr. Coleman, you may proceed.
Yeah, I filed a written motion. I have no doubt the court's reviewed it. I'll just hit the highlights if I may, Judge. The criminal history, I just would ask that the court reevaluate the bonds in light of this defendant's criminal history that includes a conspiracy to possess or distribute cocaine out of the federal court, 2010, unlawful carrying a weapon, Jefferson County, 1994, possession of controlled substance, 1998, an adjudication for possession of marijuana, state jail amount of marijuana, 1998, and a arrest for an aggravated assault that was ultimately dismissed. I think it's still probative in this setting, that history. And in addition to the criminal history, Judge, I'd ask that the court consider the fact that this defendant allegedly committed this new offense of violation of protective order while out on bond for violation of protective order, and it involved the same victim, Judge. I think there are a lot of concerning issues here related to public safety and the safety of the victim in this case. I submit to the court that $100,000 bond on each of these cases is insufficient. I'm proposing a bond of $250,000 in this case.
Yeah.
I'd ask the court consider this.
I'm printing a couple of PCs as well. Give me just a second. I'm gonna get some stuff printed out so I can take a look at that. The PC in both of the in all of the cases. So, okay, I see. So the one of the stalking and protective order is the same.
Yeah, yes.
PC.
That's right.
Mr. Parker?
Your Honor, I would like to point out that this is, he and his wife are going through a divorce, and it's been nasty. Part of the communication or contact with her was because she wanted him to see the child and told him to come get the child, and that's why I was there. I think I can't just and give me, Judge, I haven't talked to him after he bonded out, so I don't have a whole lot of information. And I just received the new case, so I'm not familiar with all the facts of the new case. So I'm limited to what I know. But my communication with him is that he's been contacted by her, and I'm sure she was admonished by Judge Freeze or whoever that to not contact him. But he did say that was one of the reasons she has contacted him to see his child, and then she tries to use that against him, and which is common. We see this a lot of times when there's a divorce going on, and they want to use anything they can. But we're asking that. I mean, he's on there's third-degree felonies, and $100,000 is a high bond. He had some help on the first two cases. I'm not sure if he's going to be able to have that help on these cases, but we're asking to leave the bond the same, $100,000 on with other restrictions I think is appropriate for these types of cases. If he was out and was intended to hurt her, he could have hurt her. I think, even the facts that Mr. Coleman has raised and some of the stuff is that if he was around her, he could have hurt her if he wanted to. But I think it aligns with what he is telling us, that he was, even though he shouldn't have gone over there to see his child, that's more than likely what happened. So we're asking to keep the bond the same, Judge, with other monitoring restrictions.
Killed myself, silly. What not? Killed myself.
Right, so Mr. Cruz, if you have a protective order against you, I know what those say, and I know what the judges and the magistrates tell you about that. No one can give you permission to violate that protective order. And if you guys were just talking about a visitation of your child, I wouldn't have a probable cause that has an allegation that there was 96 text messages, 47 emails, 9 voicemails left stating that you don't care what the protective order says and that you're going to do what you want to do. In addition to pulling in the driveway, that's on February 23rd. 2 weeks later, same thing, numerous calls, and the officers locate you in your vehicle a block away from the house driving past. So it obviously, regardless of whether you have already done anything to hurt her, my job is to make sure that that doesn't happen. And I feel like you have completely disregarded the protective order that was placed on you and the rules that were placed on you down in another court. And so at this time, I'm going to grant the state's motion. I'm going to raise the bond in cause number 26, DCCR 1060, which is the last offense date of March 1st of 2026. I'm going to raise that bond to $250,000. Condition of that bond, if you make it, is that you wear a GPS monitoring device at all times and that you would be on house arrest as well. So you would not be allowed to leave your house. I am going to modify the conditions of your bond in the 2 other cases that you've already made bonds on. Additional bond conditions in those 2 cases, which is 26 DCCR 0373 and 0374, are that you have a GPS monitoring device on at all times and that you are on house arrest. You're not allowed to leave your house without my permission. All right, you can go back with the bailiff. We'll set your case for an announcement.
The bond amount stayed the same in that one?
Yes, I didn't
Okay.
change those bonds amount. I raised the last one
Okay.
and made those modifications.
Okay.
It's the state of Ohio versus Robert Kevin Deweese. You feel you're making this decision of your own free will without any pressure from anyone?
No, I do feel pressure, but I'm willing to take it.
Okay, well, let's talk about that for a minute. What pressure do you feel?
I feel like that I'm getting not the best deal.
Can you speak up a little?
I'm not really feeling like I'm getting the best deal, a fair deal in this matter. I
Okay,
feel like that I don't have any other option but to do this.
well, you do have one option. You have a right to have a trial. If the state cannot prove these facts against you beyond a reasonable doubt, then they would not be able to obtain a guilty verdict against you. But if they can, and they do, then there would be greater penalties. So
Yes,
that's,
Your Honor.
I'm sorry?
Yes, sir.
Okay. I want to make sure that you feel that you're making this decision voluntarily without anyone pressuring you to do it.
Yes, Your Honor.
Okay, you're doing it voluntarily?
Yes.
What is your plea to count 2 rape by force or threat of force?
Guilty.
Can you speak up?
Guilty.
What is your plea to count 3 gross sexual imposition with the victim under 13 years of age and a prior conviction for gross sexual imposition with the victim under 13 years of age?
Guilty.
What is your plea to count 5 kidnapping with a sexual motivation specification?
Guilty.
I'm sorry.
Guilty.
What is your plea to abduction, a felony 3?
Guilty.
I accept your plea. Is there a statement from the victim?
Yes, Your Honor. The victim's representative, her mother, is present and would like to address the court.
Okay.
Mommy, I don't want this memory anymore. Mommy, I'm scared. These are the words that my 6-year-old daughter told me on February 6th, 2026. When we were waiting for a police officer at 5 Below in South Lebanon. As a mother, I never want my child to be scared or harmed. That day, there was a lot of both. We had gone to 5 Below just around 3 p.m. to get headphones for a new electric piano that my daughter had. While there, my daughter had an accident while using the restroom. Little did we know, after holding the door open for us, that the same person had been following us. They followed me and my daughter to the back of the store. We were stalked and spied upon as the door was closed. Later, seeing the store camera footage, I saw the image that I saw turned my stomach. I saw us being followed, having someone listen outside the door, seeing that same person touching themselves in the hallway as I stood inside that locked restroom, trying to make my distraught daughter feel better about something that had very rarely happened to her. But the most nauseating thing was that, when my back was turned, a predator had took it upon themselves to trick my daughter. I had told my daughter that I would find her new pants if I could. I wanted to protect her dignity, so I left the room and instructed her to lock it and not open the door unless I came and knocked in a very particular manner. But a predator had been listening in on our conversation, and within seconds of me leaving that restroom, our stalker came back and was knocking on that door, not just once or twice, but 4 separate times. My rule-following daughter decided to open the door, thinking it was me, as she had been instructed, but that was all it took. A predator had found us, stalked us, and then used an identified opening to take advantage and assault my daughter. When my daughter left that restroom, she was angry. She yelled at me and cried. Once outside, she told me that a man had come in and touched her, and that man had run away. My heart broke and I panicked and I ran into the store and called the police. Our world had been turned upside down. After going through the discussions with the sheriff's office, we were told to go to Cincinnati Children's Medical Center. The following weeks were filled with even more doctor strips. We started trauma therapy on February 20th, and then we quickly upped the number of visits to twice weekly. These took her out of class, and she started complaining about stomach aches, headaches, and the inability to focus. We took her to her PCP to see if anything else could be the cause, and we took her to an optometrist to see if the headaches were a result of needing glasses. Everything pointed back to the physical reaction due to the violation she experienced on February 20th, or February 6th. This slowly evolved further. She doesn't sleep in her bed anymore, opting to come to my bedroom to co-sleep because she doesn't want to be alone. She asks if her bad guy can make fake money and escape to hurt other families. She has trouble trusting other people, including adults, and during a trip to a local indoor playground, she came to me sobbing and said, "I don't want to be here anymore. I have no one that I know. I can't trust anyone." And we left one of her favorite places within 30 minutes of arriving. That's when she told her brother about the incident for the very first time. While in a single-stall bathroom, her brother was being silly, and she became enraged and yelled at him to not open the door. She said, "Don't do that. It's very dangerous. You should never, ever open the door when you're in the bathroom. It can cause really scary and bad situations like the one I was in. A man came in the bathroom and hurt me. Don't open the door. You need to be safe and make sure you are addressed and with your mom." In that moment, through her pain and fear and anxiety, my daughter was trying her best to protect her brother. She's a brave and strong girl. But I've been asked to pass along the following message to Mr. DeWeese. My daughter says, "You're a bad guy. I don't know why you choose to hurt kids. Stop doing it." And for me as a mother, I would like to say, Mr. DeWeese, I'm disgusted by you. Your actions will forever affect our lives. I don't think you are redeemable. I think you like hurting kids and that you're a predator. I think that you're a danger to society, and you need to reflect on your actions, and you should never go around another child again. Thank you.
Thank you.
The defendant's conduct on February 6th was that of a predator. Did exactly as Ms. Fink described and followed them into the bathroom where he encountered the victim. He has a history of multiple convictions for gross sexual imposition, multiple convictions for voyeurism, convictions for public indecency, convictions for failure to notify and failure to register under his sex offender registration requirements. He has been on post-release control on numerous occasions and has violated every time. He is a danger to society, and we would ask the court impose the 30 to 35 and a half year sentence.
All right, thank you.
For the record, he does have 168 days of jail time credit.
Thank you. Mr. Brunner, anything on behalf of Mr. Deweese?
Thank you, Your Honor. Mr. Deweese has written a couple of letters here, but I'll start by saying, first, I'm in agreement with the 168 days of jail time credit. I ask the court credit that towards the sentence. Throughout the pendency of this case, I have gotten to know Mr. Deweese. I have spoken with family members of his. Now, none of this is an excuse, and obviously this was a horrible crime and event, and I know that Mr. Deweese, for what it's worth, is sorry for having done this. I think when you ask him why he did this, I'm not even sure that he's able to answer that. I think there's some kind of compulsion going on here. You know, when talking with him about his childhood, he's had a difficult life, and obviously that doesn't excuse victimizing other people. But I did want to make the court aware. I mean, his father passed when he was 5. His mother left. He bounced around from foster home to foster home. He went to numerous schools because he really didn't have a home. Then as he transitioned into adulthood, he continued to struggle with homelessness and kind of rootlessness and aimlessness, obviously, started picking up criminal charges, and here we are. I know there were some mental health motions filed in this case, and I think that a large part of Mr. Deweese's issues, I think in the present situation, I've spoken with his brother. He had been, I know the court's aware, he was released from prison 3 days prior to this incident. When he was released, he was 5 hours from home. He was given $100 and put on a bus. He came down here. That during that time there was a snow emergency. He was trying to gain some kind of transitional housing and wasn't able to enter that program due to the snow emergency. And so I think it's tragic and horrible for the victim in this case. And I know Mr. Deweese is apologetic for that. And I know he wants to apologize personally.
Yeah.
But I did want to make the court aware of some of the things that Mr. Deweese has been dealing with. I know that he gets emotional when talking about this. And again, that none of that alleviates anything that happened to this little girl. I just wanted to make the court aware of kind of Mr. Deweese's background, some of the things he's been dealing with. I know that he has taken advantage of some of the programs that have been available to him in the jail. And I know that he intends on, when he gets to the Department of Rehabilitation and Correction, taking as many classes as he can. I know his goal someday when he's released from prison is to have as normal a life as he can, because I think tragically for so many people, including Mr. Deweese, he has not been able to do that so far in his 37 years.
All right, thank you. Mr. Deweese, is there anything you would like to say, sir?
Yes, Your Honor. I'm sorry. I didn't even know that I hurt you guys that bad. And there's nothing I could do to change that. I feel horrible due to my mental health problems. I did something I didn't even realize what I was doing. And I wrote you this letter. I could try to read to you. I just want to say that there is no words to tell you just how sorry I am for what happened. And I would literally do anything to go back in time and change things. I want you to know that I never meant to harm anyone, and I genuinely am sorry from the bottom of my heart. I don't know if you believe in God, but God can fix and heal everything, because with God all things are possible. I pray that you have good and wonderful life after this, and that nothing stops you from making all your dreams come true. I'm not a mean person, I want you to know that, and I wish you nothing but the best of it in your life. I hope you find love, joy, and happiness after this, and never look back. I know that today my life will never be the same, and this is the very worst day of my life. But I just pray that you can find peace and happiness in your life. And I hope you know that God will help you and be there for you and your daughter and everything you do in your life. I hope you have a good rest of your day. I'm sorry, and I hope that you know again, I'm deeply, deeply sorry for everything that happened. Thank you for your time. And I pray that you will forgive me one day. I had no clue how bad I'd hurt you guys. I didn't know that. I'm sorry.
Is that all?
Yes, Your Honor.
Okay.
I didn't realize how much damage I caused, you know. I didn't even realize that when I was doing it, I felt like I wasn't even there. And I woke up after this happened. And as soon as it happened, I said, I'm sorry to the girl. I said, I'm sorry. And I meant that. I felt scared and I didn't know what was going on until after it all happened. I feel terrible. I'm going to have to live the rest of my life with what I did. And I wish I could take it back. I do. Like, I'm scared, you know. I know what happened is not good, but I hope you'll have mercy on me and understand a little bit where I'm coming from. I feel sick. I wish I could take it back. That girl didn't deserve that, you know. I'm not a mean person. I believe in God. I wish that it didn't happen. And I pray that everything will be healed one day, you know, and that you'll have mercy on me. And I'm sorry, Your Honor.
All right, thank you, sir. Many times these mental health issues are over our head.
Yeah.
The bottom line is you're not going to be in a position to harm anyone else, and maybe you can find some satisfaction in that. If you cannot control yourself, then you can't harm other people, so you know that you have to be somewhere where this cannot happen again. That's part of the purposes of the law and protecting the public in this case, and it applies to the sentences that you're receiving here today.
Yeah.
And I try to understand what you're saying and expect you do regret it. I hope it's for the proper purpose, and I'll take you for your word at that. But you can't do this.
You're right, Your Honor.
So this is the only way in society we can deal with this. Sentence in count 2 is 11 to 16 and a half years. The sentence in count 3 is 60 months to be served consecutive to the sentence in count 2. The sentence in count 5 is 11 years in prison. The sentence shall be served consecutive to the sentences in counts 2 and 3. The sentence in count 6 is 36 months in prison to be served consecutive to the sentence in count 2, 3, and 5 for an aggregate sentence minimum definite term of 30 to a maximum indefinite term of 35 and a half years in prison. For the consecutive sentences are not disproportionate to the seriousness of the offender's conduct and to the danger the offender poses to the public. And there's also a finding that his history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public, including children, from future crime by the offender. You do have a right to appeal this finding, this sentence today. Do you have any questions, sir?
Will he'll be helping me with that?
I can do that for you
Okay.
if you would like me to. I'm happy to.
Okay.
Okay, any other questions?
No, Your Honor.
Okay, this matter is concluded.
Thank you, Your Honor.
Please rise.
Thank you.
Up on your brother.
Court is adjourned.
I'll call your
You can be
brother, let him
seated.
know what's going on, okay? I think she's gonna go over the registration stuff with you, Charlie.
A mother walked into that courtroom to speak for her 6-year-old daughter, a little girl who no longer sleeps in her own bed, who can't trust strangers, who tells her brother never to open a bathroom door alone. Kevin Dwys had been released from prison just 3 days before this happened. He had multiple prior convictions for the same type of offense. He found them in a store, followed them, waited, and when the mother stepped out for one moment, he knocked on that door 4 times until the little girl opened it. The sentence? 30 to 35 and a half years. The little girl's message to him: "You're a bad guy. I don't know why you choose to hurt kids. Stop doing it," out of the mouths of babes. If this case moved you, hit that like and share this so more people are aware of what predators look like. And subscribe. We cover the cases that matter every single day.